24 at 8:31 a.m.
Good morning, Mr. Chapman.
Good morning, Your Honor.
You can proceed when you're ready.
Thank you. Before the court is Jordan Robinson. Mr. Robinson is here today after failing to appear before this court on November 1st of 2023. Bond is currently set at $2,699. This is the second bench warrant. He reports no employment. Last payment made on this account was in July of 2022. And for the record, that was a $300 bond forfeiture. Front of the court recommends that a reasonable bond be set in this matter and to be scheduled for hearing on March 20th, 2024 at 8:00 a.m. before this court.
Mr. Robinson, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on March 20, 2024 at 8:00 a.m. Are you able to post a bond, sir?
No, sir.
Okay. Well, I am going to reduce your bond in hopes that you could be released pending that hearing, but you do have a sizable arrearage in this matter, and you haven't paid in going on 2 years now. So what the court's going to do, I'm going to set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. You're free to go. Have a good day.
8:41 a.m.
Good morning to both of you.
Good morning.
Court will note that, again, there have been some front of the court objections in this matter. Ms. Spratling, it's my understanding that you had, in fact, made the correction, submitted them to the front of the court just about a week or so ago. Is that correct?
That is correct.
Okay. I will tell you the front of the court's about 2 weeks out now, so it'll take about 2 weeks for us to get back, approval on this.
Okay.
I'll ask Mr. Spratling, are you disputing or contesting anything in this case, sir?
No.
Okay. Spratling, in this matter, you had stated in the complaint that you had resided in the county of Calhoun and the state of Michigan for more than 180 days immediately preceding the filing of the complaint. Is that correct?
Yes.
Were all of the allegations in the complaint true at the time you signed them, and do they remain true?
Yes.
You state that there has been a breakdown of the marital relationship to the extent that the object of matrimony had been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. Is that a correct statement?
Yes.
Is there any chance that you and the defendant can reconcile and live together as husband and wife?
No.
Ma'am, are you currently pregnant?
No.
Okay, thank you. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending receipt of the front of the court approval. You're not divorced until I actually sign the judgment, which again may take a couple weeks. As soon as we get that back, we'll get it entered, and then you'll be divorced at that time. So best of luck to both of you. I hope everything works out. Court will end these proceedings. You're free to go and have a good day.
You as
Yes,
well.
I can hear you.
Thank you very much. Okay, let's go.
Okay. Mr. Hamilton, in this matter, you're before the court charged with a civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges, sir?
Yes, I do, Your Honor.
I advise you have a right to an attorney. The court will appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yes.
Are you doing so freely and voluntarily?
Yes, Your Honor.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No, Your Honor.
Court will find that Mr. Hamilton does freely and voluntarily waive his right to an attorney in this matter. Mr. Hamilton, before we start, I'll have you and Ms. Petrulio raise your right hand. We'll have you sworn in, sir, and we'll proceed.
I do.
Okay, thank you. Ms. Petrulio, you can proceed.
Thank you, Your Honor. This is the case of Connie Henry versus Jeffrey Hamilton. Mr. Hamilton is before the court by way of a bench warrant after he failed to appear for an adjourned hearing on September 8th, 2021. There are no current charges in this case because the minor child has emancipated. And the court ordered that he pay $100 per month, which includes the service and processing fees each month. The last payment that he paid was $300 on May 26, 2021. As you can see, it is not posted bond. He's had 11 prior show causes. This is his 12th bench warrant, and there have been 6 findings of contempt. In the last year, he should have paid a minimum of $1,200. He's paid nothing. The arrearage on this case is $8,469.62. Mr. Hamilton booked into the county jail on March 4th. He has credit for 9 days. He also has a 90-day jail sentence who served back on January 19th, 2016. And there are no state owed arrearages. It's all owed to Ms. Henry.
Okay. Mr. Hamilton, do you contest or dispute any of the statements made by Ms. Petrulio?
I can barely understand, but I guess I don't. I was paying 2 child supports at once, and I got vertical real bad where I'm swaying and interfered with my eyes and that. I guess everything's right, I guess.
Okay. Do you have any questions for Ms. Petrulio?
No, I just thought this case was dropped. It was on my other child support in Hillsdale County was dropped. I was paying 2 child supports out at once. Cody Lockridge and then with Connie here.
Okay. Well,
And then I got told one of the kids ain't mine, it's supposed to be my dad's.
okay. Well, that doesn't involve
That was
this
by-
child, so
that-
I don't
that
know
was
how
by
that's
her
relevant.
Yeah.
Okay. What can you tell me, sir? Obviously you haven't paid in a lot of years. Why is that?
Yeah, I turned around. I thought I was reopening a business and that, and things just went through with my ex-wife and that. She sold the building and that, and skipped state. And I tried to work and that. I got vertigo and then it's kind of hard with vertigo. I'm going to doctors right now that I got arrested. I got something about back of my head and I don't know what it is. Something about red blood cells and white cell thing. But if she give me another chance, I can start sending payments. I thought this case was dropped. That was my mistake. It was Hillsdale County that was dropped.
Okay. Well, you're not working now?
I know, but I can start sending payments though.
How can you do that if you're not working, sir?
I can manage on it, send it. I just gotta get my right doctor. I'm not getting my right medication in here.
Okay.
I can start sending it if you just give me one more chance.
Well, I'm asking you how you're gonna do that, sir. If you haven't paid for a number of years, I understand you think that the matter might have been dismissed. You know now that it hasn't been dismissed. But if you're not working, how are you gonna make your payments?
Yeah, I gotta find a job and make the payment.
Okay. Let me ask you, in the last year, what have you done to acquire employment?
And I've been last past year I've been doing plasma. I've been homeless for like 3 years.
Okay.
The only thing I get is food stamps.
Okay, so your plan of working is simply wishful thinking on your part because you haven't done anything to acquire employment.
I've been homeless.
Okay.
I'm living back in Albion right now, and I'm getting a job right now. Or I can get a job in that. This vertical, it's movement. I'm trying to get disability and everything.
Okay. Have you tried to get disability in the past?
And I tried, but they denied me, but it's something else right now. And that's something about red blood cells and white cells.
Okay.
I was going through the process. I had a CAT scan before they picked me up. I don't know what the results was in Jackson County.
What's your education background, sir?
10th grade.
Have you tried to get a GED?
Not since I've been with Connie.
Why haven't you done anything to get a GED and improve yourself, make yourself more capable of being employed?
I've always been working.
Okay, that wasn't my question. Is why have you not sought to get your GED so that you are more employable?
I didn't think about it. I'm 50-some years old. I ain't even seen my kids since they were small.
Okay, anything else you'd like to tell me, sir?
No, that's it, Your Honor.
Okay. Ma'am, is there anything you'd like to inform me of?
Yes, he has several 6+ Facebook pages, and the latest one states that he was working. I submitted this October 10th, 2024 to the my child support account that I have. I submitted it, and he was working at the Dollar Tree June 11th, 2023, and also a night closer at McDonald's on June 3rd, 2023. And also back in July 14th of 1990, he was working at J&M Plating, and he doesn't do his taxes. I don't have the proof, but he was taught to use somebody else's social security number, and he doesn't file taxes because he's not submitting the proper social security card. And his son, Cody Lockridge, lived with me for a minute, and he did admit that he was using his social security card.
Hold on, ma'am, hold on. Sir,
Okay.
It's not your time to talk, so be quiet.
Okay, okay.
Sir, be quiet. Ma'am, go ahead.
Okay, like I said, and also May of 2023, he was working at Lowe's. And also from December 13th, 2013, till December 31st, 2021, he was working as a manager at that hole in the wall treasure up there on Page Avenue in Jackson. And again, he's working and not turning in, not filing taxes.
Okay. Anything else you'd like me to be aware of, ma'am?
Just, he's had all over these years, he's never tried to improve. He's never tried to help with the kids. He had opportunity to see the kids. He didn't want to see them, but that's, a whole different story. The kids are grown. They still don't go around him. They're in their 30s. If it, says anything. So,
Okay.
but that's all I have to say.
Okay, thank you, ma'am. Sir, she's test or stated about various places that you had worked just the last year. Dollar Tree back in June of 23, McDonald's, and then Lowe's in May of 23. Were you working at all those places, sir?
Yes, Lowe's paid every 2 weeks. She got payment on that. The hole in the wall treasures and that I was running the business for my ex-wife for room and board and that, and she's been paying my ex-wife and her husband have been paying her the child support. When my vertical was acting worse and everything, that's when I worked at Dollar Tree, and then I had to quit. McDonald's is only 3 hours. Dollar Tree was only 5 hours. I can't work. That's when it started hitting me worse.
Okay.
Yeah. But she was getting, my ex-wife was paying payments on a credit card to her and that for the child support, $100 a month all the time.
Okay. Well, nothing was being paid through the front of the court, correct?
Oh, my ex-wife was paying everything when I was doing the hole in the wall treasures.
Okay.
I never received any money from him except for through child support.
Okay, thank you.
He was over here at the court when I had to pay $600 real quick.
Okay. Anything else, sir?
No, my blood pressure is up like 190 something right now.
Okay.
I'm going
Well,
through with all that.
court proceedings will do that. If you get a job and you work and you pay your support, you could probably eliminate some of that condition.
And
Excuse me, can I say?
This is all new to me. This just hit me right before I came in, Your Honor.
Okay. What, ma'am? You had something else to add?
Reason why he hasn't filed taxes.
Okay, I don't care about that. I mean,
Okay, I'm just saying that was, you know,
he's not doing it, and again, something
Right.
you have to deal with.
I don't
In
even
this
see that
matter-
way.
In this matter, the court has heard the
One of the
testimony. Testimony is that the respondent in this case has a long history in this matter, that he has an arrearage of approximately $8,500. He's only required to pay $100 per month. That he claims that he can get a job and start paying, but he hasn't done so. That he is stated that he had attempted to previously try to get disability. He was denied on that. He claims that he's going to try it again, that he has a 10th grade education. However, he has not attempted to do anything to get a GED to improve himself so that he could be employable. That in this case that the mother has testified, which he has acknowledged, that he did work some places in 2023, notwithstanding that he had not made any payments in this matter since back in May of 2021. So we're going on 3 years now before any payments have been made. Clearly in this matter.
Last year, I mean, I worked.
Clearly in this, okay, sir, I'm done listening to you. Be quiet. In this matter, he has clearly had the ability to pay. He has not paid anything in this matter since May of 2021, notwithstanding him having the ability to do so, recognizing it was a limited ability when he was working at those places in 2023, but he could have done something, and acknowledged that his obligation, because the kids have emancipated and are older, so he could be paying something. In this matter, he has not done so. The court will find that he's failed to exercise due diligence, failed to refuse to comply with the order of the court in this matter, and that he is therefore in contempt of court. Is there anything you'd like to say before sentencing, sir?
I'll go ahead. I need my medication right.
Okay.
I promise I'll make the things. I just.
Well, all I can say in that, sir, is I'm sure over the last approximately 3 years, last 3 years, you probably promised a lot, if not to me.
I had a job last year and that making it while I was homeless and they took out child support.
Stop talking, sir. I don't want you talking.
One of the kids ain't even mine.
Stop talking, sir. Court will note that he is not paid, and again, the approximate 3 years, recognizing that the court has found him already in contempt of court. In this matter, he has served he had served 9 days in jail. His credit for 9 days served. He had previously had a 90-day jail sentence. The court, because it is a subsequent, again, conviction, the court is in this matter going to sentence him to 90 days in jail with credit for 9 days served. The court would allow him to purge himself of contempt by paying the sum of $1,000. That will be the order of the court. You can
If I die in here, I'll
proceed
see
with
someone.
that, Ms. Petrolio. Thank
That's all I
you.
have.
Thank
I'm
you,
sorry.
ma'am, for appearing and
Thank you.
You have a good day.
Thank you, Your
All
Honor.
right, thank you.
Thank you.
Anna Prater versus Derek Prater.
Good afternoon to both of you. When I was preparing this matter for trial today, I note that the court had provided a case scheduling order to the parties back on November 1st, 2023, in which the parties stated that the only issue was property dispute or property division in this matter. Is that accurate, Ms. Prater?
Yes.
And Mr. Prater?
Yes.
Okay. Court would note in this matter that leading up to trial, the court did not receive from either of the parties a property division chart. Is that accurate, Ms. Prater? You didn't file a property division chart?
Yes.
And sir, you didn't either?
Correct.
Okay. Well, the reason I say that is if you look back at the case scheduling order, court will note that mediation was set for January. I know mediation didn't occur, but it was set initially for January. The property division chart states that charts shall be filed and exchanged no later than 21 days after the first mediation date. And that goes on. If one party fails to file a chart, the court will use the filing party's chart to determine property and its value. If both parties fail to file, the court will assume there are no significant property issues. So because neither of you filed a chart, the court is deemed that there are no property disputes in this case. So what the court is going to do, because there has not been compliance with the case scheduling order, is that the court is going to refer the matter back to mediation. You can resolve all issues of property at mediation. So I don't know if you had conversations at all with the mediator. And I'll state that the court is doing this and referring it back pursuant to Michigan Court Rule 2.401, parens B, parens 2, parens A, parens double I, in which permits that the court shall establish time for events and adopt other provisions as the court deems appropriate in this matter so that the matter will proceed in an orderly fashion. When the parties do not comply with that, the court in its discretion can impose sanctions on a party. That's pursuant to the DeRay Development LLC versus Perrin at 288 Mishap 143 in 2010 case. Did you have any conversations with the mediator that would previously set to do this case, ma'am?
I had talked to her over email a couple times, but that was it.
Okay. And sir, did you as well?
Yeah, I was a part of the same conversation.
Okay. I don't know why, or I do note the report that came in said that she deemed the mediation to be inappropriate in this matter. I don't know why. There are reasons that it might be inappropriate, but you can usually take care of that based upon if in fact there's a PPO or something of that nature. You can always, we have parties will meet at the courthouse. We might have one party on one floor, one party on the other floor, such that they never come in contact with each other. I don't know if that was an issue or not. I just don't know. So I think what I'll do in this matter is send it back to the mediation clerk to assign a new mediator and have it mediated in April. Because I don't think you can get in before that time anyway. So we'll have it mediated in April, and I'll tell you at that point, because again, the charts were not filed, you're going to have to resolve the matter through mediation. So I mean, what it means is that you're going to have to be diligent in attempting to get matters resolved. And at such point as you do resolve those, then Ms. Prater, you're going to have to file and prepare a proposed judgment of divorce in this matter, which would address all the issues of property and address all the other issues that need to be addressed, even though you've resolved them. So that would mean that you'd have to address all the issues concerning the children as well. Ms. Prater, do you have any questions?
I just have one. So the property that we're discussing was recently repoed due to refusal of working together. Is the mediation going to even be able to do anything now that it's repoed?
Well, have you discussed what you're going to do as it relates to any potential debt because of the repossession?
He thinks we should just split what's left. I disagree with it, but I feel like where we're at now, I just have to count my loss with it.
Okay. Mr. Prater, is that your understanding that, again, the only issue was the vehicle and that's repossessed, and you're saying that should be divided 50-50?
Yes.
Okay. Well, typically, I'll say, Ms. Prater, that is the position this court has taken multiple times, is if there's a repossession and it's in, basically you took it out at the time during the marriage, that each of you would be responsible for 1/2 of that particular debt. No different than if it was a credit card during the marriage or something of that nature.
Right.
So if that's the only issue and you want to address it in that manner,
Excuse me.
you can do that in the proposed judgment, and that would dispense with having to go to mediation.
Right.
Because obviously it wouldn't make any sense for you to go to mediation, incur some additional, few $100s when you already have the issues concerning that debt.
Yep.
So.
But yeah, that's where I'm at with it. I'm ready to just count my loss, call it a day.
Okay, sir, I'll ask, so Ms. Prater, you're agreeable to, again, dividing that debt on the repossessed vehicle, that you each would pay 50-50 of that debt, provided that the creditor goes against you. Is that correct?
Correct.
Okay. Sir, likewise, are you agreeable to that?
Yes.
Okay. Then, Ms. Prater, you can include that in the proposed judgment, and that it would simply state that each is responsible for one half of that debt. I would state to you, I also include a provision that states, in the event that the creditor comes after either of you and collects more than one half, because anything we put in here does not, again, prohibit a creditor from going after either of you for the entire amount. But you can put a provision in the judgment, in the event that the creditor comes after and collects more than one half of the amount, that the opposing party would be responsible to reimburse the paying party up to their, anything above their one half. That way we don't have to come back, let's say 6 months or 9 months or a year from now, and you're saying, well, they collected it all from me and he hasn't paid, or he say the same thing. They collected it all from me and she hasn't paid. This way, you know that if either of you is required to pay more than your one half, you're entitled to reimbursement from the other party. Okay?
Okay.
So you can put that in the judgment. Did we take proofs on this?
I was just about to say, we should
Okay.
take the proofs.
Ms. Prater, in this matter, you filed a complaint for divorce, seeking a divorce from the defendant. And at the time that you filed that complaint, had you resided in the county of Calhoun, you can put your hand down, in the county of Calhoun in the state of Michigan for more than 180 days immediately preceding the filing?
Yes.
And were all of the allegations in the complaint true at the time you signed them, and are they still true?
Yes.
You state that there has been a breakdown of the marital relationship to the extent the object of matrimony has been destroyed, and there remains no reasonable likelihood the marriage is going to be preserved. Is that correct?
Yes.
Is there any chance that you and the defendant could reconcile, live together as husband and wife?
I don't think so, no.
Are you currently pregnant, ma'am?
No.
The court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs pending receipt of the judgment of divorce in this matter. Ma'am, you're going to have to prepare a judgment of divorce. You're going to have to prepare a uniform child support order and a judgment information form. Those three documents, they'll have to be submitted to the front of the court's office to get their approval.
Okay.
If in fact the defendant will sign the judgment and the UCSO, then once you get the front of the court approval, you can simply forward those into the court, and then we will get those entered at that time. Okay?
Okay.
If we can have the judgment and the UCSO at that time. If you are using a service, ma'am, for this, you can, like MichiganLegalHelp.org or so, you can simply get on.
Is his frozen for you?
Yeah.
Okay, because he's frozen on my end.
Yeah.
Okay, I think we're back. Can you still hear us?
I can hear you now.
Yeah,
Actually,
I'll get some press.
Sorry, we just had Zoom.
Oh, there it goes again.
Yep.
Zoom crash. Prater, do you have any questions at this point? Ma'am?
Oh,
I do.
wait a moment.
Nope.
Okay. Sir, do you have any questions?
No.
Okay. Well, thank you. And that's what you need to do. I'll let you go before, unfortunately, it crashes again. So, you're free to go. Have a good day. And, you're not divorced until I actually sign that final paperwork, which still may take a few weeks.
Thank you.